Welcome to today's webinar, COVID-19 Vaccines and the Workplace, What Canadian Employers Need to Know. I'm Shane Todd. I'm a partner in Fasken's Toronto Labour Employment Human Rights Group. I'm joined by LEHR colleagues from across Canada, Erin Porter, a partner in the Toronto office, Valérie, a partner in our Montreal office, Kristen Wu, an associate in our Vancouver office, and Justin Pung, an associate in our Toronto office. Before we begin, I have a few housekeeping notes. We have an online survey that we'd like you to complete. At the end of the webinar, please click the survey link underneath the video to fill in the survey. These help us determine future topics, and your input is greatly appreciated. We love questions. During the webinar, if you have a question, please type your question into the chat box beside the video. We'll do our best to answer all the questions we can. We're here if you have problems during the webinar. If you need technical support, please click the Tech FAQs button or the Tech Support chat, both of which are located under the question chat box. We know a lot about COVID-19. If you're looking for COVID-specific information, we have a wealth of information in our COVID-19 Knowledge Center. You can find that at fasken.com. Finally, we love giving these webinars. Our next webinar is held on April 20th, beginning at 2 p.m. Eastern Time. The topic will be accommodating mental health in the workplace during the pandemic. Please visit the Fasken Institute section on fasken.com to register. You'll also find information on all of our upcoming events. On the next slide, you'll see the agenda that we're going to cover today. Today, we're going to talk about where we are now in the pandemic and the vaccine rollout. After we do that, we'll take a walk back in time to discuss some prior case law on workplace vaccinations. The rest of the presentation we've structured around issues you might consider as you prepare a vaccination policy, rather than how lawyers typically think about these issues as a legal issue by issue setup. We're going to talk about can and will you require vaccination for employees? If you cannot or will not require vaccination, how might you encourage people to get vaccinated? How are you planning to deal with employee objections? Which of those objections trigger your employer duty to accommodate employees? Can you request or require disclosure of vaccination status? And if so, how can you use that information? On the next slide, we'll begin with where we are now. Well, we're more than a year into the pandemic, month 13, if you want to call it that, 2020 version 2.0, if you want to call it that, whatever you're calling it, we're a year in. March of last year, I presented to you about responding to the pandemic. So it's fitting that I'm here almost a year later to talk to you about the vaccine that is our greatest hope in ending the pandemic. I think it's fair to say that it's been a year of massive change. I think it's also fair to say that it's been an unequal impact on Canadians. We've seen huge number of job losses, mostly concentrated in industries affected by our stringent public health measures. Food services, retail trade, tourism, and the like all have been greatly impacted. Things are looking better on the economic and job front as we move further into 2021. I saw a Statistics Canada report recently that said in February, the economy added 259,000 jobs after falling 266,000 over the prior 2 months. That means our unemployment rate fell 1.2 percentage to 8.2% in February. That's the lowest rate it's been since March of 2020. Most Canadian provinces and territories are in various states of pandemic response, stay at home, shut down, however you want to phrase it. Our economic recovery has no doubt been helped by the fact that governments had started to loosen restrictions. We've seen that in Toronto, recently announced that personal care services will be reopening on April 12th. That's probably welcome news for those of you who still require a haircut. This loosening of public health restrictions is happening despite the fact that some public health officials are saying we're now in a third wave of COVID-19. Canada's Chief Public Health Officer has stopped short of calling it a third wave, but has also presented data showing rising case counts, increased hospitalizations, and ICU use. We've seen rising cases among young adults, particularly serious cases, and we've seen spiking numbers of COVID variants among the new infections. Dr. Tam has described the variants as a threat of, as elevating the threat of an uncontrolled epidemic growth rather. We know that vaccination is underway, but we also know that public health measures have to be maintained. It's anticipated that a return to normal life can't be expected until all eligible Canadians over 16 have their double dose of vaccine. That's what we hear from Public Health Canada. What we hear from the expert panel advising Ontario's government is different. They published a briefing note on Monday saying that daily infections are near the height of the second wave. Hospitalizations are now 20% higher than they were in the start of the last lockdown. BC announced this week a third, what they call circuit breaker style lockdown, with restrictions on indoor dining, group fitness, and worship gatherings. So we have sort of a change, a loosening of restrictions in some areas and a tightening of restrictions in other areas as the pandemic seems to be entering a third wave. There is hope in the form of vaccines that have been approved. There are 4 approved for use in Canada, as you'll know, 1 from Pfizer, 1 from Moderna, 1 from AstraZeneca, and 1 from Johnson & Johnson. The AstraZeneca one has been in the news recently. 1.5 million doses were to arrive in Canada, I believe today, as part of a loan from the US government. At the same time, we've had the National Advisory Committee on Immunization issue a decision recommending the restriction of their use. That AstraZeneca vaccine is not to be used for people under 55, according to that recommendation, because of concerns about rare but serious complications. I think that's the 3rd time that they've altered their guidance about this particular vaccine in the frame of a couple months. And that's possibly going to contribute to some vaccine hesitancy. What I think we're headed for, and what we may already be in, is a race between variants and a potential 3rd wave of the pandemic and a rollout of our vaccination. On the next slide, we'll look at how that vaccine rollout is going. There's currently no legal requirement to receive a vaccine, either under legislation or public health rules. It's not something you're required to do. Some public health legislation does give government the power to order vaccination. In Quebec, according to Section 123 of the Public Health Act, government has the right to impose vaccination on all or a part of Quebecers. Despite that, no Canadian government has indicated that they'll make it mandatory. They're relying instead on public education and personal willingness to get vaccinated. It seems like that confidence is well placed. Public polling suggests that most Canadians are willing to voluntarily vaccinate. An Angus Reid poll from March, conducted between March 1st and March 4th, found that 66% of respondents said they would get the vaccine as soon as possible. That's up from last year in September, where only 39% said they would get the vaccine as soon as possible. I assume they're not giving it to others. We'll see if recent changes in guidance around AstraZeneca's vaccine has impacted that willingness. We may be eager to get vaccinated. I know that I certainly am, as soon as possible, to do things to get us back to normal life. But that might not be the reality for most of us. The Government of Canada, I think most of us will agree, did a good job entering into advance purchase agreements to buy enough doses to vaccinate all Canadians. Getting those doses delivered to Canada and those doses into the arms of Canadians has proved to be more challenging. The rollout's been left to the provinces. Ontario's breaking it into 3 stages, one running from December to March, one from April to July, and one from July onwards, prioritizing high-risk populations, people who need to be vaccinated more urgently because they are at increased risk from COVID-19. Each province has its own rollout program. They're all using a relatively similar approach to prioritize higher risk populations. On the next slide, we'll see the progress that we've made to date. Now, this infographic was pulled on the weekend, so it's no longer current. But of 39 million Canadians, as of this morning, there are 4.6 million who have received at least one shot of the vaccine so far. Only 672,000 have been fully vaccinated. When you look at Ontario, that's about 107 million people who have received one shot, or about 11.7% of the population. In Quebec, there's about 1.2 million people who have received at least one shot of the vaccine, about 14.7% of their population. Notably, no one has been fully vaccinated in Quebec. In BC, there's about 600,000 people who have received at least one shot of the vaccine, or about 11% of the population. On the next slide, you'll see how far we have to reach our vaccination goals. Again, this infographic was pulled on the weekend, so it's changed a little bit. But if our goal is to have 75% of Canadians receive at least one dose by the end of September, we need to administer 28.5 million shots to people. That's the point at which Dr. Tam says we might see a return to normal life. As of the weekend, you'll see from the slide, we were at about 10% of this goal. And I checked shortly before this presentation began, and we're about 12.1% of that goal. On the next slide, I have one final section before we move into substantive issues. I want to leave you with two final thoughts to frame our discussions about the legal issues arising from vaccination. The first is that the question of mandatory vaccination of workers is still not a practical one. Vaccine supply is very limited. It's controlled by the government. Administration is being controlled by the provinces. It's rolled out to prioritize high-risk populations. It'll be some time before there's sufficient supply of vaccine in Canada for us to consider requiring vaccination of most workers. When we get to that stage where we have enough supply, we might find that voluntary vaccination addresses the issue. As I said, the majority of Canadians want to be vaccinated. They want to do their part to speed a return to normal life. The second issue is that the issues we're talking about, or the second thought, is that the issues we're talking about are extremely fact and context specific, and circumstances are changing day by day, week by week. What's permissible in one workplace may not be permissible in another workplace, or what's permissible from one group of workers in your workplace might not work for another. What's permissible now may be or what's not permissible now, I should say, may be permissible at another time as conditions change. For example, if we see a spike in cases, hospitalizations, or death, or as we learn more about vaccines and their long-term effects, or if the government intervenes. Things have changed. We've seen that all along during the pandemic. You only need to look at the guidance on masks, temperature checks, and mandatory health screening of workers, and how that has evolved during the pandemic to see how quickly and completely things can change. With those two thoughts, I want to turn things over to Erin to talk about our prior case law on vaccination policies.
Thanks, Shane. And as we'll see on the next slide, there are some key considerations that I will be going over. And the number one question that we received ahead of time about for this webinar was whether or not an employer could introduce a mandatory vaccination policy. And so I'm going to state right up front, the legal answer you all love to hear, it depends. So for everybody who is waiting for the answer to that question, you've now received your answer, and you can log off knowing that it will depend on the facts of the situation. So unfortunately, we don't have a clear-cut answer, but we do have a hint of where arbitrators may go or courts may go when considering this issue. So as I mentioned, the first one is when we look to the legislation. On the next slide, you'll see that there's a list of legislation from Ontario where the government has taken the initiative to put in mandatory vaccination requirements. So for example, under the Ambulance Act, there is a requirement that there's a requirement that all paramedics as a term of employment be vaccinated. And they're vaccinated from a list of things that are set out in the legislation. And that would include things such as tetanus, measles, mumps, rubella. So what you would consider to be sort of your standard immunizations. They're also the same immunizations that most children would have when they go to school, and they would be set out in the Immunization of School Pupils Acts. So when you're looking at this, arbitrators have had the opportunity to consider whether or not legislative requirements for mandatory vaccines are enforceable in the context of a unionized workplace. And certainly with the Ambulance Act, arbitrators have upheld the requirement to have those mandatory vaccines. So for example, there was a decision that arbitrator Goodfellow made about with North Bay and CUPE. And in that case, one of the paramedics had decided not to get the flu vaccine. And so for a period of time under the Ambulance Act, the flu vaccine was a mandatory vaccination that was required. And he opted not to get it, not for any religious reasons or medical reasons. He just didn't think that it was appropriate or necessary for him to have it, and that the government should not be able to mandate that he have medical treatment. So as a result of his refusal to get the flu vaccine and the requirement under the Ambulance Act that he be immunized, the employer held him out of work. The union grieved, and ultimately arbitrator Goodfellow dismissed the grievance and upheld the employer's policy that all ambulance attendants must be vaccinated. Arbitrator Goodfellow looked to the legislation and said, essentially, my hands are tied. It's in the legislation. There's not much more that I can do. Similarly, arbitrator Knopf came to the same conclusion in a decision with Simcoe and OPSU. And in that case, an employee decided not to get the measles vaccine, again, measles being one of the required immunizations. And Knopf said, look, it's a requirement under the legislation. You must have it, and therefore it's appropriate for the employer, in this case, they dismissed the employee, for the employer to dismiss an employee who refused to comply. And so again, the grievance in that case was dismissed. So we have these examples where if it's a legislative requirement, an arbitrator may be likely to uphold those requirements. This doesn't take into consideration the fact that any sort of requirement could be constitutionally challenged. And certainly when the flu vaccine was introduced to the Ambulance Act, CUPE did file a charter challenge in the courts, and the government ultimately changed the legislation prior to the courts having to make a determination on that. The only other thing that I'll say about the various pieces of legislation on here is that there are industries, so for example, hospitals or healthcare, where there is a requirement to have some vaccines as well. Under the Public Hospitals Act, they state that you have to have a communicable disease surveillance program. And so there, the Ontario Medical Association and the Ontario Hospital Association determine the appropriate protocols. And so they would decide which vaccinations are mandatory in order to work in a healthcare setting. Currently, they've determined that rubella and measles, for example, are mandatory vaccinations, but there would be nothing to stop them from going through the analysis and potentially determining that a COVID vaccine was also mandatory and establishing a protocol like that. Under the Long-Term Care Homes Act regulations, it states that there must be a staff immunization program in accordance with evidence-based practices, and if there are none, in accordance with prevailing practices. So that doesn't offer much guidance, but it's also something that people in that industry may turn to and consider. So Shane has already mentioned that there is legislation as well in Quebec under the Public Health Act where the government could introduce a requirement for mandatory vaccinations, although they've currently stated that they have no intent of doing so. And similarly, the Minister of Health and Long-Term Care in Ontario has said that there is no intention at this point to introduce mandatory vaccination in the legislation. So now we'll go on to the case law. So if we look at the next slide, you won't be surprised to know that there are no cases that have currently examined a mandatory COVID vaccination policy, simply because we don't have enough vaccinations yet, right? So we haven't dealt with that. But arbitrators have looked at other policies. So for example, arbitrator Randall had the opportunity to examine whether a mandatory testing policy was reasonable. And here, CLAC had filed a grievance suggesting that the invasive procedure of having the nasal swab every 2 weeks was unreasonable and that it was unconscionable and against charter rights to require employees to do that. And Dana Randall said, no, that's not the case. When you balance the rights of the residents with the employee rights, then at the end, it's a reasonable policy, and he ultimately dismissed the grievance. So I think when you look at the quote there, and it talks about the balancing of rights, I think that same kind of reasoning can be used when you are considering whether or not a mandatory vaccination policy would be upheld. And on the next slide, you'll see that we start talking about policies where there was mandatory flu vaccination. So it's not surprising that all of these cases come out of the healthcare context, because of course that is where employers were considering implementing a mandatory flu vaccination policy. These policies would typically say that employees were required either to have the flu vaccine or to take an antiviral, or they had to hold themselves out of work during a period of outbreak. So it's confined only to periods of outbreak at this time. And the first three cases that looked at this, all of them upheld those policies. So we have cases here. There's a case from Ontario, there's one from the federal sector, and one from Alberta. So kind of across the country, they were looking at these policies, and arbitrators found that when you weigh the rights of employees and the requirement to get a flu vaccine or take an antiviral against the risk to residents, that policies that required mandatory vaccination were reasonable. And I've put in some quotes here that I think would be particularly helpful if you were looking to try and enforce a mandatory policy for vaccination now for COVID. If you go to the next slide, you'll see that things didn't stay like this. There then came a case, St. Peter's Health System, and arbitrator Charney actually was quite adamant in that these policies should not be upheld. And he said that the three cases that had been earlier decided were in fact contrary to all of the previous case law on this point, and that it would be a constitutional infringement to require people to have medical treatment. So he says that the policy was not enforceable and could not be upheld, that it was unreasonable. A couple of months later, there's now a case from Alberta, and that arbitrator goes all the way back and says, nope, Charney was wrong, distinguishes their findings from the Charney decision, and goes back and kind of follows the earlier case law. So that's where the cases stood. And I'm going to pass it over to Valérie, who's going to talk about the cases out of Quebec.
So thank you, Erin, for passing me the ball. So one case from Quebec that was following the same reasoning as the previous cases Erin was speaking about. So to give you maybe a little context on what happened in this case, the employer was a residential and long-term care center, so the same kind of establishment that was completely devastated by COVID during the first wave. So in this establishment, there was a policy that was adopted for vaccination during an influenza outbreak, and where the policy was providing that if an employee would refuse the vaccine, then it may result in the removal from the workplace because of the risk of contagion, and considering the people that we were taking care of at this establishment. So what happened in this case, you might anticipate, is that a nursing assistant was challenging the employer's decision to remove her from work for 2 days during one of the outbreak because she refused to receive a flu shot to help fight against the outbreak. So what the arbitrator considered in this decision was that the employees were clearly informed of the consequences of refusing to receive the vaccination. It was also established that the employee could not be assigned to another position, which was highly considered by the arbitrator. So basically, she could not perform any other tasks, so she was simply sent home without pay. The arbitrator considered that the employee had the right to refuse to be vaccinated, as vaccination is considered as an intrusion into the person. I will speak a little more about this later on today in the presentation. But basically what the arbitrator considered was that the employer had respected the employee's right to free choice by not imposing the vaccination on her, but that by refusing, the employee had to suffer the consequences of her choice. And then that therefore the employer's policy had a sufficiently important objective, namely the protection of vulnerable clientele, and then the withdrawal of employees for a maximum of 72 hours as per the policy was a measure that was proportional to the objective sound. So what is interesting in this case is that the arbitrator considered that the complainant could not rely on the charter to claim lost wages during her withdrawal from work. But at the same time, he also considered that the 72 hours of work policy was reasonable, which might not be the same thing if the removal from work is for a period of many months or many weeks, depending on how the whole vaccination process evolves in time. So it is one of the only cases we have in Quebec regarding vaccination policy that concerns a refusal and then a consequence. But I think it is a good, it shows well how arbitrators may think in Quebec regarding those kind of policy in this context as well. So I will pass the ball back to Erin for following cases and more case law on this subject.
Thank you. So after we looked at those initial cases, then the case law started to evolve. And if we go to the next slide, we'll see, first we looked at in the beginning, now what was next? So what was next was this series of mask or vaccinate policies. Employers had initially wanted a policy. The initial vaccination policies were about controlling employee behavior, specifically during an outbreak. The mask or vaccinate policies tried to expand on that. So they wanted now to control behavior for the entire flu season. So it wasn't just if a workplace was designated to be an outbreak, but essentially for 6 months of the year during flu season, that employees were required to either have a flu vaccine or wear a mask at work. So the first decision on this came out of British Columbia, and the arbitrator there upheld the policy and said that it was reasonable. And a lot of the same rationale as our earlier vaccination cases was utilized. So when looking at the safety, the health and safety of the vulnerable residents, that outweighed any sort of employee right, and that it wasn't a coercive policy because employees still had the option. They still had the option of deciding whether or not to receive a vaccination or to hold themselves out of work or to wear a mask, so that there were options provided to the employer. But things didn't stop there. And so as we look to the next slide, we'll see that in Ontario, there were then a series of decisions on these mask or vaccinate policies. And the first one out of the Sioux Area Hospital was from Arbitrator Hayes. And so Arbitrator Hayes said, hold on, this is completely unreasonable to ask an employee to wear a mask. And I think it's funny looking back on it now, we can see the irony perhaps in it, but you'll see the last point says, the policy makes a significant ask of unvaccinated employees, that is to wear an unpleasant mask for up to 6 months at a time. And so back in 2015, wearing a mask for 6 months was seen to be completely unreasonable. And they also looked to the fact that there wasn't very much scientific evidence to support the fact that a flu vaccination actually prevented the spread of the flu, because the flu vaccination was only deemed to be about 60% effective. And so the arbitrator found that because there wasn't enough scientific evidence to support that vaccination reduced the spread of the flu, and the fact that there was not enough medical evidence to support the fact that wearing a mask would reduce the spread of the flu, that the policy was therefore unreasonable. This was upheld, so Arbitrator Hayes, not surprisingly, followed his own decision in a subsequent decision of William Osler Health. And then on the next slide, we'll see that Arbitrator Kaplan also followed Arbitrator Hayes's decision, and this kind of became the standard for the mask or vaccinate policies. Here, Arbitrator Kaplan relied on the fact, again, that there wasn't enough scientific evidence to support that vaccination actually reduced transmission. And Arbitrator Kaplan also says, in the face of all of this, the ask that healthcare workers wear a mask for their entire shift, or possibly months on end, when entirely free of symptoms is completely unreasonable and contrary to the collective agreement. So again, you can see how much times have changed now, where we've been wearing masks for about 13 months and still going strong. So that's where we were. And now if we go to the next slide, the question is, now what? Well, anytime that an employer introduces a policy without the consent of the union, so a unilateral policy, they must keep in mind the test set out in KVP. And so I put the test on the slides here, but really the arbitrator is going to focus on whether or not it is reasonable. So is it reasonable is where most of the decision is going to be based. If we go to the next slide, we'll see that I've put a series of questions that employers will want to consider when introducing their vaccination policy. So these are some things to keep in mind when you're drafting. And I think at the end of the day, it's really going to come down to the industry. So as Shane had alluded to at the very beginning, when asking these questions, it is going to be fact specific depending on what industry you're in. You're always going to want to have the least intrusive means possible for obtaining your objective. So if you were in an office setting, for example, you're probably going to be able to obtain the objective of remaining COVID-free or remaining free of outbreak by introducing things such as social distancing, wearing a mask, working from home. So in situations like that, your vaccination policy has to take that into consideration, and it's likely that you're not going to be able to introduce something that's mandatory. If you look, however, to places such as warehouses, food processing plants, production facilities where employees are not able to socially distance, then you may say, well, we could have the objective of remaining COVID-free by introducing testing. So you have testing before the employee comes on site, and that's sufficient. So you may not be able to get away with a mandatory vaccination policy unless you can demonstrate that testing has not been sufficient. If you then look to places such as mining or the agricultural industry, where you have employees who are living on site in close proximity to one another, the question will become, again, can you remain COVID-free most of the time by having testing? And so probably yes. But if you've demonstrated that testing isn't sufficient, then maybe you can move to a vaccination policy. And it's going to be very similar reasoning that would be in the alcohol and drug policies. You know, when you look at what are the indicators for your specific site, do you have the evidence and the data to suggest that you need to have a mandatory vaccination policy? And you're always looking to what does the scientific information about the vaccination in general provide? Is it going to be that it's only 60% effective by the time you look at all of the variables and the different strains? Maybe. And if that's the case, then it's going to be harder to require a mandatory vaccination policy. But if you have a higher efficacy rate, then you may be more likely to have a mandatory policy. Finally, if you look to industries in healthcare and long-term care and retirement in particular, there you may have more success because those industries are already doing masking and PPE. They already have mandatory testing before you come on site, and they still have outbreaks. And the result of having an outbreak can be quite significant on the residents. So for example, residents are confined to their room, they have to dine alone, they're not allowed visitors. So because of those sociological impact on the residents, then you may be able to justify a mandatory policy, again, assuming that the science will support that. So those are just some of the considerations that you'll want to think about when trying to decide whether or not you can have a mandatory policy. So without further ado, I'll now pass it over to Valérie, who is going to start thinking about other things that you want to consider with your vaccination policies. Thanks.
So thank you again, Erin. So should you decide to adopt a policy, what could it contain? If it's not mandatory vaccination, what are the other topics that you could cover by your policy? So key vaccine policy issues, we'll talk about 4 different topics. The first one will be one of the most popular questions during the last few weeks, which is incentivizing vaccination. We will also cover accommodation, vaccination status, and occupational health and safety later on when I will pass the ball to my dear colleagues, Kristen and Justin. So on the next slide, so incentivizing vaccination. As we discussed earlier, just a quick reminder that the right to refuse to be vaccinated is protected under the provisions of most human rights legislations across Canada, which generally affirms an individual's right, fundamental right, I must say, to bodily integrity and inviolability. Sorry, as you may hear, I'm a French speaker by nature. So if I must add, in Quebec, for example, this right is also complemented by the provisions of our civil code, which stipulates that no one may be forced to undergo care of any nature except upon their consent. So maybe that to force vaccination is not the key. However, in our opinion, those principles does not prevent an employer from encouraging its employees to get vaccinated. As seen in the last section, case law generally recognizes that an employer may promote vaccination and conduct an awareness campaign in the workplace. In the particular circumstances of COVID-19, dehumanization is a really clear way to reduce the risk of contagion in the workplace. So therefore, we consider that an employer could be justified to give incentive or to offer incentive for vaccination to its employees in view of protecting the health and safety of its workers and sometimes of its customers as well. So as you know, governments across Canada have encouraged all those who are eligible to be vaccinated to opt for it. There is a good participation rate so far. I'm sure it will continue to go well in the next months. I will be in line to get my vaccine as well as soon as I can. But an incentive policy would be justified in support of the government's recommendation as being reasonable and non-intrusive in furtherance of the employer's occupational health and safety obligation. It is also, in my opinion, part of the moral imperative to take steps to bring the worldwide threat of COVID-19 under control. So, that being said, long story short, what types of incentives are currently used or considered by companies? So as you will see on this slide, there are a few different types of incentive that are most popular. The first being paid time off for vaccinations. Gift cards are also contemplated, bonuses, days off after the inoculation process if there's a reaction, strong and effective communication on how important the vaccination is, to remember your employees of the importance of getting the vaccine. Also, I've discussed with some clients the opportunity to give incentive to all employees based on vaccination rates. So in order to reach a rate of vaccination that would help the world or the country to get back to normal, there could be incentive based on vaccination rates as well that could be considered by employers. And another good idea would be to give access to an healthcare professional to address questions related to the vaccine. So people that would be more scared about the potential consequences, or that might watch media a little too much and are scared of anything that could happen related to the vaccine, then giving them access to an healthcare professional could help and to encourage employees to get vaccinated. So as you may have seen in the news, there are a few employers that already declared that they would pay time off for their employees to be vaccinated. It is public, it was in the news. You might have seen the Toronto Dominion Bank plan to give workers up to 8 hours of paid time off for coronavirus vaccinations. The way they would divide it would be it would be 4 hours per shot of vaccination. So workers would receive 4 hours for the first dose, and then after a second 4 hours if a second dose is required. Bridgestone said basically the same thing. So it announced a few days ago that it would offer almost $33,000 to its employees by amounts of $100 per employees who get vaccinated against COVID-19 and joining, therefore, a large group of companies that are offering those type of incentive to their employees to receive the vaccination shots. To name a few others, Canada Goose, Good Let's Build, and also Dollar General also said that they will pay their employees the equivalent of 3 to 4 hours to compensate the time off they would need to take to get the vaccine. So now that we have spoken about the different types of incentive that could be offered to your employees, what about the vaccine injury compensation, and what would be your risk of liability regarding this vaccination? I don't think it will be a big surprise for you, but should any disease or any consequences result from vaccination impair your employee or prevent them from going back to work because they would suffer consequences from the vaccine, then general accommodation would apply. There could be work or sick leave. And the third bullet point that you see must be the most scariest one, which is potential workers' compensation claims. That would more likely happen if the vaccination was being given or was taking place in the workplace. I will cover this section at the end of my presentation. But what you need to remember for this part is that should any employee be impaired or could not show up to work after vaccination because of consequences from that vaccination, then of course your general duty to accommodate would apply as it would for any other sickness or needs for your employees. So on the next section, there are a few provinces that have adopted statutory liability protection. The first one I will cover being Ontario. So basically, this law is in force as of November 2020, which is a lot of 20 in my sentence, but you get where I was going, and could be applied retroactively on or after March 17, 2020. So basically, it could be retroactive to the beginning of this pandemic. The liability protection that is proposed by this bill is, of course, subject to several exceptions. I have listed some of them, so it may give you a general idea of what it would not cover. So any acts or omission, of course, that would constitute gross negligence, that would not be protected by this statutory liability. Also, any liability claims where the relevant act or omission occurred while a law required the individuals or business operation to close in whole or in part. So basically, if you go against the law and you continued to operate your company or to do a business as usual without complying to the law, then any act that would result from this negligence or this refusal to follow the law would not be covered by this statutory liability protection. Also, another exception that is quite important and that relates to the third point I was telling you about earlier is that any claims made by employees against employers for COVID-19 exposure or infection that occurred in the course of the employee's performance at work would not be covered either by this protection. So, other thing is that this legislation does not provide guidance at the moment as to the meaning of gross negligence. If plaintiffs would intend to litigate on this basis, they will likely have to turn to the common law meaning of this term. Same goes for Quebec. Négligence grossière is kind of the same concept that also apply in our civil province. If we go to the next section, as you will see, British Columbia also adopted a similar protection based on related to COVID-19. From a discussion I had with colleagues from BC, for a business to be protected from liability under this regulation, they must have been acting in accordance with or had reasonable belief that they were acting in accordance with all applicable emergency and public health guidance. So again, like for Ontario, if any business would act against a law or a rule or any order that was adopted to fight against COVID-19 or to protect public health, then liability would not be protected by this law either in BC. So the third point, which is I would not say my favorite, but I think one that I strongly consider, especially in Quebec, and I will explain to you why, is that for most workers' compensation regimes are generally the exclusive remedy for injury or illness that is suffered in the course of employment. We remember the importance of complying with all guidelines and orders that are issued by public health authorities and workers' compensation regulators. So while preparing for this presentation, one of the questions I had in mind was, okay, but what if the administration of the vaccine ends up by taking place in the workplace? Would any employee be entitled or could file a complaint or a claim, would be the more appropriate word, to argue that the consequences of the vaccine were related to the workplace and therefore be compensated by any board for the salary loss that would be the consequence of this vaccine. So in Quebec, not that much of a surprise, but there was a case related to the policy that we saw before that were adopted for usually vaccination. There, we had a research nurse that filed a claim with the CSST after suffering a viral reaction following the administration of a vaccine. She was vaccinated at the hospital where she was working as part of the vaccination campaign that was organized by the hospital for its employees at the beginning of fall, which is the most popular season for the flu in eastern of Canada. So in this decision, surprisingly, the Commission des liaisons professionnelles, how is it, as it is called, the occasion of work, because the vaccination for linked to the work of the worker, because also that the vaccination was given at the place of work, that it was recommended by her boss, and moreover, that the worker by her work was in a situation of extreme risk. So based on that, the Commission des liaisons professionnelles considered that the consequence of the vaccination was related to work and granted the claim of the employee. It was even more surprisingly, it was confirmed by the Superior Court in judicial review as well. So the reason why I'm talking about this is that before considering any vaccination that could take place in the workplace, there are some discussions in Quebec where the government is looking for companies that would like to participate in the vaccination campaign, and before deciding to vaccine any employees in the workplace, you should be really careful in that regard, because there is a real risk of liability that could result from this vaccination. So I will now pass the ball to my colleague Justin that will speak to you about reasonable accommodation.
Thanks, Valérie. So in this section of the presentation, I'm going to discuss in some more detail the human rights aspects of a workplace vaccination policy, and specifically what kind of reasonable accommodation is required in this context. The key issue that we're really talking about when it comes to human rights is how do you accommodate an employee or employees who are unable to be vaccinated due to protected human rights ground, particularly when you have the kind of policy that mandates or incentivizes vaccination. And this is an issue for all employers because all employers in Canada have human rights obligations under provincial or federal legislation that includes a duty to accommodate. And that's certainly going to have implications if you are an employer who is actively trying to increase the vaccination rate in your workplace. And so you'll see on this slide, there's just some examples of laws that give rise to human rights obligations. We had earlier touched on the Charter of Human Rights and Freedoms, which applies to governments and certain government-related organizations. And then just beneath that point, we have some examples of human rights legislation that applies to private sector organizations. So for example, we have the Canadian Human Rights Act, which applies to federally regulated employers such as airlines, telecoms. And then for provincially regulated employers, each province and territory has their own human rights legislation. But all of these laws have pretty similar protections and principles. And so we can draw some pretty common lessons from all of them. For the purposes of this presentation, I will just focus on the human rights legislation specifically. Just to dive right into that, under these laws, employers cannot discriminate against employees based on prohibited grounds of discrimination. And by that, I just mean personal characteristics of individuals that are considered to be protected grounds. And there are some differences between the provinces and territories in terms of what counts as a protected ground. But generally, in every province and territory, you will find that protected grounds under these laws include disability, pregnancy, which is sometimes linked to other grounds such as gender, as well as religion or creed. And as I'll discuss in more detail, these are the protected grounds that we would most anticipate requiring accommodation by employers when it comes to vaccination policies. And so on the next slide, we'll start unpacking this duty to accommodate and what employers are actually required to do. So in a nutshell, employers have an obligation to accommodate the protected needs of employees to the point of undue hardship. And once the employee has shown that there is in fact a prima facie case of discrimination, by that we just mean on its face, there's a case of discrimination. Once that has been established by the employee, that's when the burden shifts to the employer to justify the conduct or practice. And at this stage, the employer needs to establish that the supposedly discriminatory standard or practice is a bona fide occupational requirement in the circumstances. What that means is that the employer must show that the conduct or practice is reasonably necessary and that the needs of the individual cannot be accommodated without incurring undue hardship. And that term undue hardship has a pretty high threshold in the case law. It involves a consideration of a variety of factors, which usually include financial hardship, security, health or safety, and other kinds of practical constraints. And to kind of break down in a little bit more detail what the duty to accommodate requires, there's both a procedural and a substantive component to it. So the procedural component is all about the process. It's the considerations, the assessments, it's the steps that are taken at the procedural level to respond to an accommodation request or an accommodation need. Whereas the substantive component is all about the appropriateness or the reasonableness of the chosen accommodation. Or conversely, it's about the reasons for not providing an accommodation, including proof of undue hardship. I think we can skip over the next slide. The next slide just essentially explains that both employers and employees have to work together to try to find a reasonable solution. And so on the next slide over, this goes into the substantive components of accommodation. What exactly is required in the context of a vaccination policy? And particularly what happens in a situation where you have a policy that mandates or incentivizes vaccination, and an employer comes up to you and says, for some reason, due to protected characteristic, they are unable to be vaccinated. This slide just gives you a few examples of some of the measures that may be considered reasonable accommodation in the circumstances. So in a scenario where an employee cannot be vaccinated, then depending on the circumstances of your workplace, reasonable accommodation in this scenario could mean enhanced health and safety measures for that employee and for their workspace. It could mean temporary reassignments or redeployments. It could mean that they have a temporary remote work arrangement, or that if they have one already, then this gets extended. And it could also mean an unpaid leave of absence. Conversely, in a scenario where your policy does not mandate vaccination, but only incentivizes it, and similarly, an employee is unable to take advantage of that, then depending on what the incentive is, a reasonable accommodation could mean providing that same incentive to that employee, subject to reasonable proof being provided. And what I want to emphasize on this slide is that ultimately reasonable accommodation requires a very context-dependent assessment to see what is reasonable and what is possible in the circumstances. It involves an assessment of the nature of the workplace, the duties of that employee, such as are they in regular proximity to employees and patrons? It may involve an assessment of what are the objectives of the vaccination policy. Is it about health and safety? And of course, a key factor in this assessment is what is the current state of public health guidance? What is recommended when it comes to the vaccination of employees? The other point I want to emphasize for the slide is that this is a non-exhaustive list. What's considered reasonable for one workplace will not necessarily be reasonable for other workplaces. And so again, it comes back to that point that accommodation is a very context-dependent assessment, and it will really depend on the nuances of your particular workplace and the nuances of that particular employee who has an accommodation need. So on the next slide, we'll start discussing more the procedural duty of accommodation. Before we get to that substantive duty to accommodation, that assessment of what is reasonable and what is possible in the circumstances, there has to be grounds for the accommodation. And here's where there needs to be cooperation between both the employer and the employee. So typically with a request for accommodation, the employer will want evidence to demonstrate that the employee does in fact have a protected ground, and they will want to see evidence to show what exactly their needs or their limitations are. And this evidence can take many forms. It could be some form of medical documentation to establish that they have a certain kind of disability, or that they are currently pregnant, and that for related medical reasons, it's not recommended that they take COVID vaccination. Evidence could also take the form of a written statement of beliefs if their reason for accommodation is that they have a religious practice or belief, or they have some creed that prevents them from taking vaccination. Similar to the last slide, this is a very context-dependent assessment in terms of what kind of evidence will be required in the circumstances. And the other thing to keep in mind is that there are limitations on what kind of evidence employers can ask for, and this will vary depending on the province or territory in question. I think we can skip over the next slide. The next slide just discusses in more detail the limitations on requesting medical information. I think we can go on to the next slide. So here's where we start getting into the specific protected grounds that may arise for this issue of workplace vaccination policies. Very briefly, this slide explains that disability is a broad concept, and that may, of course, include a certain allergy or deficiency that would prevent someone from taking a particular COVID-19 vaccination. And I think we can also skip over the next slide, which more or less expands on that issue of what is or what is not a disability. So this slide shows a case study where there was a mandatory vaccination and accommodation policy. Going back to what Erin had discussed earlier about certain healthcare industries having government regulations or directives that permit or require an employer to impose mandatory vaccination. This is one of those scenarios. Involved Sunnybrook. So we have a hospital that has a mandatory flu vaccination policy for its nurses. And in this policy, if a nurse refused vaccination because the vaccination is medically contraindicated for them, which basically means that the vaccination would be harmful and is not recommended, then that nurse would be reassigned, or they would be put on paid leave during an outbreak. If a nurse did not meet that standard of a vaccine being medically contraindicated for them, the nurse would be put on unpaid leave. So this is a mandatory vaccination policy with an accommodation measure built into it. And in this specific 2019 case, the nurse refused to take the vaccination and claimed that she had both an egg allergy and a certain enzyme deficiency that collectively meant the flu vaccination was medically contraindicated for her. And she also claimed that she experienced a number of negative symptoms in the past when she had been vaccinated. And so the issue between the parties was whether or not this was in fact true and whether the nurse was entitled to paid leave during the outbreak. And based on the evidence that was put before the arbitrator decided that in terms of the egg allergy, this was no longer considered to be an impediment to being recommended for the flu vaccination, and that there wasn't really any evidence to show that the nurse had even done allergy testing. So there was insufficient evidence for that argument. And similarly regarding the enzyme deficiency, there was no evidence to show that this would mean the vaccine was contraindicated for the griever. And what came out of the evidence was that basically the griever in this case had simply told her doctor that she had these conditions and that therefore she couldn't take the vaccine. And the doctor essentially just wrote that down and it was submitted to the hospital. And so based on all the evidence, the arbitrator concluded that the vaccine was not in fact medically contraindicated for her and that the employer was justified in imposing an unpaid leave of absence. And the takeaway from this case is that accommodation is only required for the actual objective needs of the employee. And in some cases, if there's reason to suspect the adequacy of the evidence provided, then it may be necessary to go beyond that evidence and to determine what in fact does the employee have in terms of their protected ground and what are their actual needs or limitations. The next slide involves this very similar case, this time involving an employee who was pregnant, but this case was decided differently from the Sunnybrook case. So again, it involved a hospital, or rather healthcare center. It involved a very similar mandatory vaccination policy where accommodation was built in, and a nurse who was unable to be vaccinated could receive paid leave if the vaccine was contraindicated for them. In this case, the nurse actually was vaccinated, but was unable to take an antiviral medication that was contraindicated for her. And the employer's policy was that once you took the vaccine, you had to be off for 14 days for it to take effect, and that you could only come back to work within that 14 days if you took the antiviral medication. Because the nurse could not take the antiviral medication, she had to be off for 14 days. And the question was, did she have to be paid under the policy for that 14-day waiting period? And based on the evidence that was before this arbitrator, it was decided that the standard was uncompromisingly stringent. It discriminated against the employee on account of their pregnancy. And so therefore they were entitled to paid leave during a 14-day waiting period. And again, this case is just another good reminder that where there's objective evidence to show that an employee cannot immediately or fully comply with a vaccination requirement due to a medical reason such as pregnancy, then the employer should be prepared to accommodate that and to explore what is reasonable and possible in the circumstances. And in the next slide, we'll discuss how accommodation applies in the context of religion or creed. So just going back to first principles here, it can definitely be challenging in the context of vaccination to determine what accommodation is required for someone who says that they cannot be vaccinated on account of their religion or creed. And this protected ground has pretty broad meaning under human rights legislation. It generally includes any practices, beliefs, or observations that are part of a religion or faith. And in terms of what is required, it's the employee's personal or subjective understanding of their religion or creed that is the focus. And it's not about the actual obligations of the faith or what others of that same religion, faith, or creed believe or practice. And an important point to keep in mind is that generally employers are not entitled to assess the reasonableness of an employee's religious beliefs or practices. What's important in terms of assessing this protected ground is that it's about that employee's personal or subjective understanding. The requirement on the employee is to demonstrate that their accommodation request is based on a sincere or honestly held belief or practice. And this is the standard for the purposes of the Human Rights Code of Ontario. It may vary depending on your province or territory. They do employ similar tests, but there may be certain nuances and differences between them that will require a specific assessment depending on which province or territory is at issue. And so on the next slide, we'll see how these principles apply in practice to vaccination policies. And this slide has two case studies that show the limits of accommodation for religion or creed. In the first case, the Lambton County case, a paramedic objected to his employer's mandatory flu vaccination policy and claimed that it violated his creed under the Human Rights Code of Ontario. However, he defined his creed as based on his opinion of the advantages and disadvantages of vaccination and his views on whether the mandatory vaccination policy was being uniformly applied to all healthcare workers and personnel. And so the Human Rights Tribunal of Ontario found that the employee had not actually identified any religious beliefs or practices that influenced his decision, and therefore he was not being discriminated against. And a very similar outcome was reached in the Sharma decision right below. In this case, an individual filed an application against the City of Toronto for enacting a bylaw that requires publicly accessible businesses to only permit access to members of the public who are wearing a mask or face covering. And in this case, again, at issue was his political opinions rather than a religion or creed. And so his application was dismissed. All that is to show that when it comes to accommodation in the workplace, and here we can go to the next slide, it's about identifying the needs, the actual needs of the employee in terms of what accommodation is required. It's about collecting relevant information, and it's about examining what is reasonable and possible in the circumstances. And with that, I'll turn things over to my colleague, Kristen Wu, to discuss vaccination status and workplace health and safety.
Thanks, Justin. I'm going to start with a discussion of privacy issues. So, as many employers are aware, COVID-19 vaccination raises several privacy issues, such as whether an employer can collect employees' vaccination status, how employers can use employees' vaccination status, to whom employers can disclose employees' vaccination status, and what steps should be taken to safeguard employees' personal medical information. As a starting point, employers should be aware of which privacy legislation applies to their business. If you belong to a public sector organization, for example, a public hospital, a public school, or a branch of government, then public sector privacy legislation would apply, such as the Federal Privacy Act or Provincial Freedom of Information Protection of Privacy Act, commonly referred to as FIPA. In this presentation, I'll focus on the rules for private sector businesses. If your private sector business is federally regulated, the applicable privacy legislation would be the Personal Information Protection and Electronic Documents Act, commonly referred to as the PIDA. If your private sector business is provincially regulated, then provincial privacy legislation would apply in British Columbia, Alberta, and Quebec. Those are the only 3 provinces that have provincial private sector privacy legislation. If your business is in a province that doesn't have provincial private sector privacy legislation, you're not completely off the hook. All employers should comply with privacy principles, such as seeking express consent for sensitive personal information as a best practice. Finally, I just want to mention as well that if your business is involved in the provision of healthcare services, you may also be subject to provincial health information legislation, such as the Ontario Personal Health Information Protection Act. And this legislation may impose additional obligations that may not be covered in this presentation. So the first issue I'm going to discuss is collection and use of vaccination status. Requiring proof that an employee has received the vaccine is much less controversial than requiring immunization itself, but there are still some significant privacy considerations. Information related to a person's medical condition or personal health is recognized as highly personal and sensitive, and there needs to be protection from unreasonable collection, use, and disclosure. As usual in the employment context, a balance must be struck between the employer's ability to maintain a safe workplace and the employee's right to privacy with regard to their personal health and medical records. It's worth noting as well that the appropriate balance between workplace safety and employee privacy has been shifting since the beginning of the pandemic, and it's likely to continue to evolve. For example, a year ago, most employers wouldn't have considered temperature screening any of their employees, but this is now a common practice across Canada due to the pandemic. In order to request proof of vaccination, the collection of this information must be for reasonable purposes. In the circumstances of a global pandemic, if the use is in relation to health and safety, for example, for employees who have to work in close proximity and they can't socially distance, then that would likely be a reasonable use in collection. Another acceptable use could be for employees who work in settings involving direct interaction with coworkers, contractors, customers, and other people. For those employees, the information could be used to make decisions regarding modified work schedules, work transfers, or leaves, particularly in the event of an outbreak. If the intent is to collect vaccination information from all employees, an employer would need to have a reasonable purpose for using that information. For example, if all employees will continue to work remotely without contact with others, then it may not be reasonable to collect employees' vaccination status. In general, you shouldn't be collecting personal information that you're not going to use. On the other hand, if you intend to have employees return on site later this year in large numbers, then a reasonable use could be to collect the information and use it in the event of an outbreak, or in the event that there are colleagues who are not vaccinated. An employer might use the information to make decisions about the location where the unvaccinated employee would work. It could also be used for workforce planning decisions or workforce modification requirements. But if the pandemic eventually calms down and the risk of COVID-19 is significantly reduced, or we reach community immunity, then requesting vaccination status may no longer be reasonable. So on the next slide, I discuss the next issue of disclosing and safeguarding vaccination status. Vaccination status and related information, for example, if an employee discloses that they're not getting vaccinated because of a personal medical condition, all of that information should be kept strictly confidential. The information should only be shared and accessed on a need-to-know basis or to comply with a legal order to disclose the information. And it's important to note that need to know is different than nice to know or would be good to know. Only personnel who are directly responsible for workplace planning should have access to the information. That might mean that most supervisors and managers don't need to know any vaccination status information unless until they or their direct reports are directly involved. The information should be kept securely in a separate file with restricted access. So for example, you should use password protection to protect that information. It shouldn't be kept in the employee's general personnel file. In terms of retention, the information should only be retained until the end of that individual's employment or until the information is no longer needed, because we've reached a time where workforce planning based on vaccination status is no longer necessary. Finally, it's important to note that care should also be taken to maintain the anonymity of individuals who have not been vaccinated in the workplace. On the next slide, I discuss vaccination information policies. And the importance here that I want to make is that employees should develop a robust policy to give notice to employees of the purposes of collection, use, and disclosure of vaccination information, so that employees can understand, how are employers going to be using this information? Who are they going to be disclosing it to? Is this information going to be securely stored, and how long are they going to have this information? The purposes that you outline in your policy should focus on protecting the health and safety of employees and the community. Given the sensitivity of vaccination information, employers should obtain express written consent for the collection, use, and disclosure of employees' vaccination information. A copy of your vaccination information policy should accompany the consent form when it's distributed to employees. Employers should refer to the privacy legislation that's applicable to their organization to determine what other information and obligations should be addressed in the policy. Finally, designated staff should be trained on how to collect vaccination information, how to maintain the confidentiality of vaccination information, and that includes as well protecting the anonymity of employees who have not been vaccinated. If employees have refused to provide their vaccination information, then they should be treated and considered as non-vaccinated. So now I'm going to move into a discussion of some occupational health and safety considerations. The first thing to note is it's important that everybody is clear and aware that there are currently no exemptions to workplace rules or recommended health and safety measures for those who have been vaccinated. At the present time, workers who have been vaccinated are still required to follow all COVID-19 laws, regulations, and public health guidance. As more and more of the population becomes vaccinated, it's possible and perhaps even likely that COVID-19 restrictions will eventually loosen. However, at this point, it's too early to know what post-vaccination workplaces will look like. Under occupational health and safety legislation, an employer has a duty to protect the health and safety of its workers. This duty includes taking all reasonable precautions to protect workers' health and safety, providing employees with the information, instruction, training, and supervision necessary to ensure that health and safety measures are being followed, providing clear and readily accessible communications to workers, such as a written COVID-19 safety plan, and ensuring that all public health rules and guidelines are being followed. So there are some common questions that many of you submitted prior to the webinar and that we're getting in the course of our practice. And those two questions are, what do I do with employees who refuse to be vaccinated for non-protected grounds? And can employees refuse to attend work because other employees are not vaccinated? So starting with the first question, what do I do with employees who refuse to be vaccinated for non-protected grounds? The employee can continue working. Depending on your workplace, that may mean continuing to work remotely or continuing to attend the workplace while wearing appropriate PPE and following all health and safety measures. The employer can consider temporary work modifications on a case-by-case basis, such as moving the employee's office or assigning different duties or a different work schedule. However, care should be taken to ensure that the employee is not inadvertently identified as being non-vaccinated. In other words, the employer shouldn't disclose the reason for the work modifications to others. In the absence of any protected ground under human rights legislation that would require accommodation, an employer can also consider terminating without cause if the employee refuses to take the vaccine or disclose whether they've taken the vaccine. Because this termination would be without cause, the employer would need to provide notice of termination or pay in lieu of notice. So moving on to the second question, can employees refuse to attend work because other employees are not vaccinated? Employees can generally be required to attend work. There may be some limited exceptions, for example, if they have a remote work contract, but if the employee believes that the workplace is unsafe, their remedy is to follow the procedures under the applicable OHS legislation to refuse unsafe work. In BC, the employee has to report the unsafe work condition to a supervisor or the employer, and the employer has to investigate the unsafe work condition and, if possible, correct it. If the employer is indeed complying with all applicable public health laws and guidelines, it's unlikely that employees can legitimately refuse to attend work on the basis that other employees are not vaccinated. Remember that all public health measures are currently still in effect. If masks, physical distancing, sanitizing, etc., sufficiently protected employees in the pre-vaccination world, they should still sufficiently protect employees in the post-vaccination world. As more and more people are vaccinated, we expect that the public health laws and guidelines will eventually change. For example, in BC, the Provincial Health Officer's Workplace Safety Order currently recommends remote work. This recommendation may be removed from the order later this year, but of course, we'll have to wait and see to know what the future brings. And that leads us into our Q&A portion. And I'm going to pass things back to Shane Todd, who's going to moderate some questions from the audience.
Great. Thank you very much, Kristen. I'll actually start with you because we've had a question come in. Can we ask employees to verbally confirm they've been vaccinated, or do we need to collect written proof? And a corollary to that was, can I ask the date they were vaccinated and the type of vaccine that they received?
Thanks, Shane. From a privacy perspective, asking for verbal confirmation would be the least intrusive way. And depending on your workplace, for example, if it's not, a healthcare setting, you may find that verbal confirmation is sufficient. Employees have a duty of honesty, and they can't, knowingly and deliberately mislead the employer to believe that, they were vaccinated when they weren't. The next stage, if we don't want to go with verbal confirmation, what I would recommend is having the employee provide proof of vaccination in a written form, but you don't need to photocopy or, take it away from them and put it in your file. A supervisor can review that information, confirm that, that they have been vaccinated, and then, put a check mark in like a password protected Excel document or something like that. And then to Shane's second corollary question, the date might be potentially relevant, but in most cases, it wouldn't be necessary to collect the data unless perhaps you have a safety sensitive workplace, such as in a healthcare setting. And then type of vaccine, I don't think, in my view, it's not necessary to collect unless, it comes out later on that everyone who's taken one type of vaccine and we learn that vaccine is no longer effective, in which case, we might need to backtrack and collect that information to determine who's at risk.
Great. Justin, a question came up during your presentation. Are vaccinated employees still required to wear masks or follow other public health guidance while in the workplace, even if they've been vaccinated?
Thanks, Shane. The short answer to that question is, and you hear this word a lot, it depends. And in this context, it depends on what is required under public health guidance at the relevant time. So if either the provincial, territorial, or federal governments or your local public health unit require masking in the workplace, regardless of vaccination status, which is currently what we are experiencing today, then that is the prevailing rule. And your vaccinated employee, will be treated equally as your non-vaccinated employees when it comes to that masking requirements. Conversely, if public health guidance does change, and the requirement is now that only non-vax individuals must be masked in a workplace, then those different requirements will prevail. All that to say, it's important to stay abreast of what applicable public health guidance is relevant for your workplace, to keep track of that, and to determine when vaccinated employees in your workplace can take off their mask, and when that same relaxing of that restriction will apply to the rest of your workforce.
Thanks, Justin. I think that builds on another question that I'll answer about vaccination passports. Someone asked whether vaccination passports are likely to become a thing. I saw a CNN article, I think yesterday, about the Biden administration efforts to establish a vaccination passport, or a standard by which people could prove that they had been vaccinated, with a view perhaps to what Justin's alluded to, a different set of standards that may apply to people who are fully vaccinated, whether that's at work or whether that's for travel. So I think something in that may be on the horizon. We may also see businesses that want to use it as a marketing tool. Everybody here has been fully vaccinated. This is a, quote, safer workplace for you to be in. Valérie, the next question is for you. There was a question when you were speaking about incentives and how we should treat people who have to refuse access to those incentives because of a protected ground. So if you're offering gift cards, but I can't access vaccine because of a religious or health issue, how do we handle that from an incentive point of view?
Thank you, Shane. It's a really good question. I think it really depends on what incentive is offered to employees. I think that the less dangerous one would be to compensate for time off that needs to be taken to go get the vaccine. So basically, to compensate an employee that would take some time on his working hours to go out and get the vaccine and come back should be compensated. And I think it would be easier for an employer to build a defense of non-discrimination based on the fact that the employee would simply be compensated for the time he took. There could be a different reasoning behind the question of gift cards or bonuses. But still, I think that considering the whole pandemic situation, the reasons behind the vaccination requested by public health safety all across Canada, it could be, I think, at some point the employer could reasonably defend himself on saying that it is not a discrimination. But again, if I could have one recommendation to employers that are watching us or listening to us, would be to try to focus on compensating time off. I think it's the less dangerous incentive that you could offer to your employees in this context, or the bonus on vaccination rates as well, because it would apply to everyone based on that.
Thank you. Erin, a two-part question for you. I think you win the prize for most questions posed during your section, so I'm going to give you a two-parter. If the advice is that it depends whether or not you can mandate vaccination, and it turns out in my workplace I can't mandate vaccination, can I restrict participation in activities involving someone who's not vaccinated? So can they not attend meetings in person or what have you? And a related question, what if my customer requires proof that my employees are vaccinated? What can I do to my employees in those circumstances?
So I think, first of all, I don't know if that's a great award to receive most questions. The least clear, but I do, so with regards to the first part of the question, can I treat employees differently depending on vaccination status? So for example, attending a meeting in person versus virtually, and it will depend. So as Justin had previously alluded to, there are public health guidelines in place, so you would want to make sure that you were following those public health guidelines. And if it was sufficient before, as Kristen was saying, in the pre-vaccination world, if you were allowing employees to participate, for example, in-person meetings, then there should be no reason post-vaccination world that you would now prevent them from doing that, assuming, of course, that they were still wearing all the proper PPE and things like that. Now, it may be that that's not possible. And previously, all employees had worked from home. And so if you can't guarantee safety or you're concerned about safety, then there may be situations where you do treat employees differently. And if I were a betting woman, I would suspect that down the road, we will find that public health does introduce different guidelines that will depend on whether or not an employee is vaccinated or not. Which gets into the privacy issue that we talked about, because then it will become obvious. Somebody will be wearing a mask at work, and they will be wearing the mask presumably because they're not vaccinated, where someone else won't have to wear a mask. And there have been cases that have looked at that, and arbitrators had said that that doesn't breach privacy because that's just the practical reality of the situation. The second question, Shane, you may need to remind me of the second part of my question.
What happens if I'm a customer facing organization and my customer requires proof of vaccination or only vaccinated workers on their site?
Yeah, and so it, again, you could have policies that are more stringent when you're looking at customers. So we've seen that with some drug and alcohol policies, where sometimes a mine, for example, will require that everybody who's a contractor coming onto the mine has a zero tolerance for alcohol or drugs. And those policies in that situation have been found to be enforceable because it's not the employer's own policy, but rather a contractor's policy. So you may have more leeway there. I think also this will come up again in healthcare situations where you have personal caregivers perhaps going into people's homes and things like that. And so customers there may decide that they only want caregivers who have been vaccinated. And so I think it's going to depend on the facts of the situation. You know, is it reasonable to say that all employees have to be vaccinated when faced with a customer population, for example, that has access to a clothing store where they can come in and out of the clothing store and shop and they're not vaccinated? Then it's going to be harder to enforce. But if you're dealing with a closed mine that has a zero tolerance policy for alcohol, zero vaccination policy similar to what we see with drug and alcohol policies, then you may be more likely to enforce it in those circumstances.
Great, thank you. Valérie, you talked about incentivizing vaccination through paid time off. What happens if an employee chooses to get the vaccine on their own time on a weekend that's not a working day? Would you recommend that they be paid for that time?
This is a really good question. I think it relates to the one before that was regarding employees that could argue that they refuse to get vaccinated based on protected grounds, for example, religion, which is, I think, the first one that pops in my head for that. I think that there's a difference between compensating an employee that goes to get a vaccine during his time working hours and an employee that goes during the weekend on his free time, because then he gets more than he was supposed to get on a regular work week. So basically, I think that the discrimination complaints could more arise if we treat employees if we can compensate, employees in those situations. So in situations where an employee would work his full working hours of 40 hours to give an example, and then would get 4 or 5 hours more of pay on the weekends that would add on top of what they receive during the week. So I think those situations could be one that could lead to complaints or attempt to complain against the measures that would be taken by the employer. So my recommendation would really be to try to compensate as much as we can employees for their working hours to ensure that we treat all employees the same, and at the end of the day, they all receive the same, but they get to be vaccinated during their working hours. I don't know if I was clear with my answer.
That was very clear. Thank you. I think that concludes our time. We're at 3:30. I want to thank our panelists for making the time to present today, and I want to thank all our attendees, of course, for joining us. There were lots of questions we didn't have time to get to. If you have additional questions or you need specific legal advice about an issue, please feel free to reach out to one of us directly. Our contact information is in the PowerPoint materials, which will be available later. Thank you very much, everyone, for your time.